I was halfway through my morning coffee when I looked out my kitchen window and saw 60 strangers setting up tables, tents, and a full barbecue station on my private beach in Lake Geneva, Wisconsin. My name is Marcus Chen, and I had purchased this waterfront property 6 months ago specifically because it came with deeded private beach access. Not shared access, not community access, private. The deed clearly stated that the 30 feet of shoreline and the accompanying beach area belonged exclusively to my property at 2847 Lakeshore Drive. I had paid a premium for that privilege, and now there were dozens of people treating it like a public park. I set down my mug and walked outside, still wearing my pajama pants and a faded northwestern hoodie. The morning air was crisp for late May, and the lake sparkled under the early sun. Under different circumstances, it would have been beautiful. Instead, I was watching a woman in her late 40s directing traffic like a military general, pointing at where people should place coolers and folding chairs. "Excuse me," I called out as I approached. "This is private property." The woman turned to me with a smile that did not reach her eyes. She was wearing a white visor, khaki caprice, and a purple polo shirt with an embroidered logo that read Lakeshore Estates HOA. Her blonde hair was pulled back in a tight ponytail, and she had that particular expression I had come to recognize in my months of homeownership. The look of someone who believed rules applied to everyone except her. "Good morning," she said brightly. "You must be one of the new residents." "I am Sharon Whitmore, president of the Lakeshore Estates Homeowners Association Board. We are just setting up for our annual board appreciation brunch. It is such a lovely morning for it." "On my beach," I said, keeping my voice level. "This is my private property." Sharon laughed, a tinkling sound that set my teeth on edge. "Oh, honey, I think there has been some confusion. The lake meetings are our right as HOA board members. We have been holding our gatherings on this beach for 12 years, long before you moved in. Lake meetings are your right." I repeated, unable to keep the disbelief from my voice. "This beach is deeded to my property. I have the documents." "And we have precedent," Sharon countered, her smile growing sharper. 12 years of precedent. The previous owner, Mr. Henderson, never had a problem with us using this space 4 times a year for board functions. He understood the importance of community. I looked past her at the growing crowd. There were at least 60 people now, maybe more. Someone had brought a portable speaker, and Jimmy Buffett was playing at a volume that definitely violated noise ordinances. A group of men were digging holes in my sand to anchor a volleyball net. "I do not care what arrangement you had with the previous owner," I said. "This is my property now, and I am asking you to leave." Sharon's expression hardened. "Mr. Chen, is it? I suggest you check your HOA bylaws. Section 17, paragraph 4 clearly states that common areas may be utilized for board functions with proper notice." A notice was sent to all homeowners 3 weeks ago. "This is not a common area," I said, my patience wearing thin. "And I am not part of your HOA." That got her attention. Her eyes narrowed. "Everyone in Lakeshore Estates is part of the HOA. It is mandatory." "Not according to my deed," I replied. "My property predates your HOA by 40 years. I checked before I bought. I'm not subject to your bylaws, your fees, or your rules." For a moment, Sharon looked genuinely surprised. Then her face flushed an unflattering shade of red. "That cannot be right. Every property in this development is part of the association." 90% of them are," I said. "Mine is not. Neither are the 3 other original properties that were here before the development went in. Now please remove your party from my beach." Sharon's voice rose an octave. "Absolutely not. We have been planning this event for months. The caterer is already on their way. Board members have driven from as far as Kenosha. You cannot expect us to cancel over some supposed property dispute." "It is not a dispute," I said. "It is a fact. And if you do not clear out in the next 10 minutes, I am calling the police." "Go ahead," Sharon said, crossing her arms. "Call them. We will see what they have to say about your hostile attitude toward community building." I pulled out my phone and dialed. The Lake Geneva Police Department answered on the second ring, and I explained the situation to the dispatcher. She told me an officer would be there within 20 minutes. Fine, Sharon said when I hung up. We will wait for the police. In the meantime, we are going to continue setting up. Freedom of assembly is a constitutional right. On public property, I said. Not mine. Sharon turned her back on me and clapped her hands loudly. Everyone, continue with setup. We have a minor situation, but it will be resolved shortly. The local authorities will confirm our rights to this space. I watched in disbelief as the party preparations continued. A catering van pulled up, and workers began unloading trays of food. Someone inflated a massive unicorn float and tossed it into the water. A teenager started a game of frisbee dangerously close to my dock. I went back inside and retrieved my property documents. The deed was crystal clear. The survey map showed the exact boundaries. The title insurance policy confirmed that there were no easements, no shared access agreements, and no HOA covenants attached to my land. I had done my homework specifically to avoid this kind of situation. When I returned to the beach, Sharon was holding court with several other board members, all of them shooting dark looks in my direction. I recognized a few faces from around the neighborhood, people I had waved to while checking the mail or walking to the small downtown area. They were not waving back now. Officer Brandon Martinez arrived in a marked patrol car and I met him at the property line. He was younger than I expected, maybe early 30s, with a professional demeanor that immediately put me at ease. "Mr. Chen," he asked, and I nodded. "Can you walk me through what is happening here?" I explained the situation while showing him my documents. He studied them carefully, then looked at the crowd on the beach. "And they are claiming they have permission to be here." "She is claiming something about precedent and HOA bylaws," I said. "But I am not part of the HOA." Officer Martinez nodded. "Let me talk to them." I watched as he approached Sharon, who had arranged her face into an expression of concerned innocence. I could not hear the entire conversation, but I caught fragments. "Officer, thank goodness you are here. This new resident is trying to prevent a long-standing community tradition." "Ma'am, do you have written permission from the property owner to be here? We have 12 years of precedent. The previous owner always allowed it." "That is not the same as permission from the current owner." "These are his property documents. They clearly show this is private land." Sharon's voice rose again. "This is harassment. He is targeting us because we represent community values." Officer Martinez remained calm. "Ma'am, I need you and your guests to vacate this property." "You are currently trespassing." "Trespassing?" Sharon's shriek could probably be heard across the lake. "This is public waterfront. We have every right to be here." "The waterfront is public," the officer agreed, "but this beach area is private. If you would like to move your gathering to the water itself or to an actual public beach, you are free to do so, but you cannot remain on Mr. Chen's property without his permission." "This is absurd," Sharon sputtered. "I am calling my lawyer and the mayor and the county commissioner." "This is going to be a much bigger problem than this young man realizes." "That is your right," Officer Martinez said. "But for now, I need everyone to pack up and leave. If you refuse, I will have to start issuing citations for trespassing." There was a long moment of tense silence. Sharon stared at the officer, clearly trying to decide if he was bluffing. Then she spun on her heel and clapped her hands again. "Everyone, pack up. Apparently, our community is no longer welcome in our own neighborhood. We will be relocating this event, and we will be addressing this situation through proper legal channels." The grumbling that followed was loud and sustained. People shot me dirty looks as they folded chairs and collected coolers. The caterer looked annoyed about having to reload the van. Someone made a show of popping the unicorn float, even though they could have just deflated it normally. "You are making a huge mistake," Sharon hissed as she walked past me. "The HOA does not forget. Neither do property owners," I replied. It took nearly 40 minutes for everyone to clear out. Officer Martinez stayed the entire time, which I appreciated. When the last car finally pulled away, he turned to me. "For what it is worth, you are completely in the right here," he said. "Your property documents are airtight, but be prepared for them to make things difficult." "What can they actually do?" I asked. "I am not part of their HOA. Legally, not much," he admitted. "But HOAs can be creative when they feel slighted. Document everything. Keep copies of all your property records easily accessible, and if they trespass again, call us immediately. Do not try to handle it yourself." "Thanks for your help," I said sincerely. "Just doing my job," he replied with a slight smile. "Nice property, by the way. I can see why you would want to protect it." After he left, I spent an hour cleaning up the mess the HOA party had left behind. There were cigarette butts in the sand, crushed plastic cups, and someone had spilled what looked like fruit punch on my dock. The holes from the volleyball net poles were still there, ugly divots in the otherwise smooth beach. I was hosing down the dock when my phone rang. Unknown number with a local area code. "Hello, Mr. Chen, this is Patricia Holloway from Lakeshore Estates HOA Board. I am the Vice President. I am calling to apologize for this morning's misunderstanding." Her tone was much more conciliatory than Sharon's had been. I turned off the hose. "I appreciate that. Sharon can be a bit overzealous in her community duties," Patricia continued. "She genuinely did not realize there was a dispute about the property boundaries. We would like to resolve this amicably. Would you be willing to meet with the board to discuss a compromise?" "There is nothing to discuss," I said carefully. "This is my property. There is no dispute about boundaries. The deed is clear." Of course," Patricia said smoothly. "But surely we can work something out, perhaps designated days when the HOA could use the space with your permission. We would be happy to compensate you." "I am not interested in renting out my beach," I said. "I bought this property for privacy." There was a pause. "I understand, but I hope you will reconsider. The HOA provides many valuable services to this community. It would be unfortunate if you chose to position yourself as an adversary to your neighbors." The implied threat was not subtle. "I am not positioning myself as anything. I just want to enjoy my property in peace." "Of course," Patricia said again, her voice cooling slightly. "Well, the offer stands if you change your mind. Have a good day, Mr. Chen." She hung up before I could respond. The next week was quiet. I worked from home, taking video calls from my office that overlooked the lake. I swam in the mornings before the water got crowded with boats. I grilled dinner on my deck in the evenings. It was exactly the peaceful lakefront life I had envisioned when I bought the place. Then the letters started. The first one arrived on a Tuesday, official looking with the HOA logo in the corner. It informed me that my property was in violation of neighborhood aesthetic standards due to unapproved exterior paint colors. My house was sage green, the same color it had been for at least a decade based on the photos from my home inspection. I tossed the letter in the trash. The second letter arrived on Thursday, claiming my dock violated setback requirements and needed to be moved. I pulled out my survey. The dock was exactly where it had always been, well within legal boundaries, and predated any HOA regulations by decades. That letter joined the first one in the trash. On Saturday, I found a bright orange violation sticker on my mailbox claiming my lawn was overgrown. I had literally mowed the day before. The grass was maybe 2 inches tall. On Monday, another letter arrived threatening fines for an unauthorized structure, which turned out to be my generator shed that had been there since the house was built in 1978. I was starting to understand what Officer Martinez had meant about HOAs being creative. Wednesday brought a certified letter requiring a signature. This one claimed that I owed 12 years of back HOA dues totaling $48,000, plus interest and late fees bringing the total to $73,000. That one did not go in the trash. That one went into a folder that was rapidly filling with HOA correspondence. I called a real estate attorney named David Brennan, whose office was in downtown Lake Geneva. His receptionist got me an appointment for Friday afternoon. David's office was in a restored Victorian building with views of the lake. He was in his 60s, with silver hair and the kind of calm confidence that comes from decades of experience. I showed him everything: my property documents, the survey, the title insurance, and the growing stack of HOA letters. He read through it all methodically, occasionally making notes on a legal pad. When he finished, he sat back and smiled. "This is the most clear-cut case I have seen in years," he said. "Your property is absolutely not subject to HOA control. These violation letters are baseless, and this demand for back dues is particularly egregious." "So what do I do?" I asked. "First, I will send them a cease and desist letter clarifying your property status and demanding they stop this harassment campaign," David said. "If they continue, we can pursue legal action for harassment and possibly even file a claim for damages if they have caused you financial harm." "How much is this going to cost me?" I asked. "My retainer is $3,000, he said. "But honestly, I think one strongly worded letter will solve this problem. HOAs tend to back down when they realize someone is serious about fighting back and has solid legal ground. They rely on intimidation because most homeowners do not have the resources or knowledge to challenge them effectively." I wrote him a check on the spot. David's cease and desist letter went out the following Monday via certified mail to Sharon Whitmore, Patricia Holloway, and the HOA's registered agent. It was 3 pages of precise legal language that essentially boiled down to: "Stop harassing my client or face a lawsuit you will definitely lose." I expected that to be the end of it. I was wrong. That Thursday evening, I was making dinner when I heard engines on the water. I looked out to see a flotilla of boats anchored just off my beach. There were at least 20 of them, ranging from pontoons to speedboats to jet skis. Music blared from multiple sources. People were swimming, drinking, and having what appeared to be an impromptu party. I walked down to the dock. Sharon was on a large pontoon boat, wearing oversized sunglasses and holding a wine glass. "Beautiful evening," she called out cheerfully. Nothing like enjoying our public waterways. I understood immediately what she was doing. The water itself was public. She could not be on my beach, but she could anchor just offshore and make my life miserable from there. "Nice try," I called back. "I have no idea what you mean," Sharon replied with mock innocence. "We are simply exercising our right to enjoy Lake Geneva. These are public waters after all. We could be here all night if we wanted, maybe all weekend." The music got louder. Someone on a jet ski started doing donuts close enough to my dock that the wake rocked my kayak loose from its tie. I managed to grab it before it floated away. I went inside and called the Lake Geneva Police Department again. The dispatcher listened to my complaint and explained that as long as the boats were in the water and not on my property, there was not much they could do unless noise ordinances were being violated. She said she would send someone to check decibel levels. An officer showed up an hour later with a sound meter. By that time, the HOA flotilla had turned their music down to a perfectly legal volume. They waved cheerfully at the officer. Sharon even offered him a beer, which he politely declined. "They are staying just inside legal limits," he told me apologetically. "Unless they actually come onto your property or violate specific ordinances, my hands are tied." The boat stayed until nearly midnight. The music, while technically not violating noise laws, was constant and deliberately annoying. I could not enjoy my deck. I could not open my windows. I definitely could not sleep. When they finally left, Sharon made sure to shout, "See you tomorrow night." I called David Brennan first thing Friday morning and told him what had happened. "That is harassment," he said firmly. "Deliberate and targeted. Document everything. Take photos, videos, note the times and dates. We are building a case here." "For what?" I asked tiredly. I had gotten maybe 3 hours of sleep. Intentional infliction of emotional distress, harassment, possibly even stalking depending on how far they take this, David said. "And we can seek a restraining order if necessary." The flotilla returned Friday night, Saturday, and Sunday. Each night they pushed the boundaries a little more, jet skis buzzed closer. Music started earlier. On Sunday, someone brought an air horn and blasted it randomly. I documented everything. Photos, videos, time-stamped notes. By Monday morning, I had a comprehensive record of what Sharon was calling her "Lake Meetings Are Our Right" campaign. Apparently, she had been posting about it on the neighborhood Facebook group, rallying support against the hostile new resident who hates community. Monday afternoon, David filed for a restraining order based on harassment. The hearing was scheduled for the following week. In the meantime, the violation letters continued. My garbage cans were too visible from the street. My outdoor furniture was not approved. My garden gnome violated aesthetic standards. I did not have a garden gnome, but that did not seem to matter. Wednesday brought a new escalation. I came home from a grocery run to find a county inspector on my property with a clipboard. "Marcus Chen," he asked, looking up as I got out of my car. "That's me. Can I help you?" Dale Morrison, Walworth County Building Inspector. "I received a complaint about unpermitted additions to this property. I need to inspect your structures." "What unpermitted additions?" I asked, though I already knew this was Sharon's work. "The complaint mentions a dock, a shed, and what is described as a deck expansion," Dale said. He seemed professionally bored, like he dealt with this kind of thing all the time. "Everything on this property was here when I bought it 6 months ago," I said. "And most of it has been here for decades." "Then you should not have any problems," Dale said. "Mind if I take a look around?" I let him inspect everything. The dock had permits from 1982, the shed was original to the house. The deck had been properly permitted and inspected in 2001. Dale checked everything thoroughly and made notes. "Everything looks in order," he finally said. "Whoever filed this complaint either had bad information or was wasting everyone's time." "I have a pretty good idea who it was," I said. "The HOA has been harassing me since I refused to let them use my private beach for parties." Dale sighed. "Yeah, I figured it might be something like that. We get a lot of calls from HOAs trying to use the county as their personal enforcement arm. For what it is worth, your property is clean." "I will file my report saying no violations found." "Can you tell me who filed the complaint?" I asked. "It was anonymous," Dale said. "But it came through the Lakeshore Estates HOA website contact form, real subtle." After he left, I added his report to my growing folder of documentation. The restraining order hearing was on Tuesday morning at the Walworth County Courthouse in Elkhorn. David and I arrived early. Sharon showed up with Patricia and 2 other board members I did not recognize, along with their attorney, a sharp-looking woman in her 40s named Jennifer Kowalski. We went before Judge Raymond Foster, a stern-looking man in his late 50s who had a reputation for not tolerating nonsense. David presented our case methodically. The property documents proving my beach was private. The photos and police report from the original trespassing incident. The timeline of harassment letters. The videos of the boat flotilla deliberately making my property unusable. The false county inspection report. "Your Honor, this is a clear pattern of targeted harassment," David concluded. "Mr. Chen simply wants to enjoy his legal property rights without being subjected to constant intimidation and disruption." Jennifer stood up. "Your Honor, what Mr. Brennan characterizes as harassment is actually just normal community activity. My clients have been using this beach area for 12 years with no complaints. Mr. Chen's hostility toward the HOA has created this conflict, not the other way around." "The beach is his private property," Judge Foster said flatly. "That is not in dispute based on the documents submitted." "We are not disputing his property rights," Jennifer said smoothly. "We are simply saying that the boat activities he complains about took place in public waters. My clients have every right to enjoy Lake Geneva. If Mr. Chen finds their presence disruptive, perhaps he should not have bought waterfront property." "Did you review the videos?" David asked. "They are clearly targeting his specific location." Boats anchored directly in front of his property, music aimed at his house, jet skis repeatedly buzzing his dock. This is not random lake activity. Circumstantial, Jennifer argued. Lake Geneva is a popular recreational area. My clients enjoy boating. They cannot be expected to avoid an entire section of the lake because one hostile resident complains. Judge Foster held up a hand. I have reviewed all the submitted materials. Ms. Kowalski, your argument might hold water, no pun intended, if these boat gatherings had occurred randomly. But according to the evidence, they happened 4 consecutive nights, always in the same location, always directly in front of Mr. Chen's property and always including HOA board members. That establishes a pattern. But Your Honor, Jennifer started. I am not finished, Judge Foster said. Additionally, the volume and nature of the violation letters sent to Mr. Chen, many of which appear to be completely baseless, constitutes harassment. I am granting a temporary restraining order. The HOA board members and any persons acting on their behalf are to maintain a distance of at least 200 feet from Mr. Chen's property, both on land and water, except for normal passage on public roads and waterways. The full hearing for a permanent order will be scheduled within 30 days. Sharon made a noise of protest, but Jennifer put a hand on her arm. Furthermore, Judge Foster continued, I am ordering the HOA to cease all violation notices to Mr. Chen unless they can provide clear evidence that his property is actually subject to HOA covenants, which the deed documents suggest it is not. Any further baseless complaints or harassment may result in contempt charges. Am I clear? Yes, Your Honor, Jennifer said tightly. David smiled. Thank you, Your Honor. We walked out of the courthouse into bright sunshine. David was pleased. That went better than I expected. Judge Foster does not mess around. So they have to leave me alone now, I asked. They are supposed to, David said. Whether they actually will remains to be seen, but now if they violate the order, there are real consequences. I drove back to Lake Geneva feeling cautiously optimistic. Maybe this nightmare was finally ending. That optimism lasted exactly 3 days. Friday afternoon, I received a certified letter from a law firm in Milwaukee. It was a lawsuit. The Lakeshore Estates HOA was suing me for $73,000 in back dues, plus an additional $50,000 in damages for undermining community cohesion and damaging the HOA's reputation. I immediately scanned and emailed it to David. He called me within an hour. This is a slap suit, he said, strategic lawsuit against public participation. They are trying to intimidate you with legal fees and the stress of litigation. The good news is it is completely frivolous. The bad news is we still have to respond to it, which means more time and money. How much are we talking? I asked, defending against this, probably another $10,000 to $15,000 in legal fees, David said. But here is the thing. Wisconsin has anti-SLAPP statutes. If we can get this dismissed quickly and prove it is frivolous, we can recover our attorney fees from them. Plus additional damages. So they could end up paying me, I asked. If we play this right, yes, David said. But it is going to be a fight. Are you prepared for that? I looked out at my beautiful private beach, the lake sparkling in the afternoon sun. I had worked hard for this place. I was not going to let Sharon and her HOA bullies take it from me. Yeah, I said. I am prepared. David filed a motion to dismiss based on Wisconsin's anti-SLAPP law. The hearing was set for 6 weeks out. In the meantime, the restraining order seemed to be working. No more boat flotillas. No more violation letters. I actually got to enjoy my property for the first time in weeks. I started getting to know my other neighbors, the ones who were not on the HOA board. Most of them were friendly and sympathetic. A couple named Jim and Maria Rodriguez lived 3 houses down. They invited me over for a barbecue one Saturday evening. We are glad someone is finally standing up to Sharon, Maria said quietly as we sat on their deck. She has made this neighborhood miserable for years. Why does not anyone else challenge her? I asked. Jim laughed bitterly. Because most people are locked into the HOA, they cannot sell without dealing with it, and Sharon is vindictive. Cross her and suddenly you are getting violation notices weekly and fines for things that do not even exist. Have you thought about getting her voted out? I asked. She runs the elections, Maria said. And she has a core group of supporters who always vote as a bloc. The rest of us have basically given up. That does not seem legal, I said. Probably not, Jim agreed, but hiring a lawyer to fight an HOA is expensive. Most people just try to keep their heads down and avoid her attention. Well, I am already in it, I said, and my lawyer seems to think we can win. I hope so, Maria said, for all our sakes. The anti-SLAPP hearing finally arrived in early July. The courtroom was different this time, a civil court in Milwaukee, since that was where the HOA had filed their lawsuit. The judge was Sandra Pembroke, a no-nonsense woman in her early 50s with a reputation for efficiency. David presented our argument that the lawsuit was frivolous and designed purely to harass me into compliance. He outlined the timeline: my refusal to allow the HOA on my property, the subsequent harassment campaign, and now this baseless lawsuit claiming I owed dues to an organization I was never part of. Jennifer Kowalski argued that the lawsuit was legitimate because, in the HOA's view, my property should have been part of the association, and someone had made an error decades ago when the development was created. That is not how property law works, Judge Pembroke said dryly. You cannot retroactively add someone to an HOA because you think they should have been included originally. Is there any evidence that Mr. Chen's property is actually subject to your covenants? We are investigating the possibility of an administrative error, Jennifer said. That is not evidence, Judge Pembroke replied. Do you have a deed restriction, a recorded covenant? Anything showing this property is legally part of your HOA, not currently in our possession, Your Honor, Jennifer admitted. Because it does not exist, David interjected. This property predates the HOA by 4 decades. There is no legal basis for their claim. Judge Pembroke reviewed the documents in front of her for a long moment, then she looked up. Motion to dismiss is granted. Furthermore, I find that this lawsuit meets the criteria for Wisconsin's anti-SLAPP statute. It was clearly filed to intimidate Mr. Chen and punish him for exercising his legal property rights. Mr. Brennan, please submit a detailed accounting of your fees and costs. The HOA will be responsible for paying them, plus statutory damages. Sharon looked like she had been slapped. Patricia whispered urgently to Jennifer, who was flipping through papers like she might find some magical document that would change the judge's mind. Additionally, Judge Pembroke continued, I am referring this matter to the Wisconsin Department of Financial Institutions for investigation into the HOA's practices. Filing frivolous lawsuits to collect non-existent debts may constitute fraud. That got everyone's attention. Jennifer went pale. Sharon stood up abruptly. Your Honor, I need to consult with my board, Sharon said, her voice shaking slightly. You can consult all you want, Judge Pembroke said, but my ruling stands. This case is dismissed with prejudice, meaning it cannot be refiled. The HOA will pay Mr. Chen's legal fees and statutory damages. And I suggest you think very carefully about your future actions toward Mr. Chen, because I can see a pattern here that speaks to potential bad faith. We left the courthouse and walked to a nearby coffee shop. David was grinning like he had won the lottery. That could not have gone better, he said. Judge Pembroke absolutely eviscerated them and referring them to the state. That is huge. The Department of Financial Institutions has real power over HOAs. They could face serious penalties. What happens now? I asked. Now we calculate the full amount they owe you, David said. My fees, court costs, plus statutory damages, which in Wisconsin can be up to $10,000. All told, the HOA is probably looking at paying you around $30,000. I nearly choked on my coffee. Seriously. Seriously, David confirmed. They tried to intimidate you with a bogus lawsuit and it backfired spectacularly. Sometimes karma works fast. The next few weeks were blissfully quiet. I got a call from an investigator with the Department of Financial Institutions, who asked detailed questions about my interactions with the HOA. I told her everything and provided copies of all my documentation. "This is very helpful, Mr. Chen," she said. "We have received several other complaints about this HOA's practices. Your case provides clear evidence of a pattern of abuse." In mid-August, I received a check from the Lakeshore Estates HOA for $32,400. It was accompanied by a terse letter from Jennifer Kowalski stating that the payment was made under protest and should not be construed as an admission of wrongdoing. David laughed when I showed him the letter. "They still do not get it. The judge already found wrongdoing. That ship has sailed." I deposited the check and treated myself to a new kayak and some improvements to my dock. It felt like a well-earned victory. Then September brought a new development. I received a letter from the Department of Financial Institutions informing me that the Lakeshore Estates HOA was under investigation for multiple violations, including fraudulent billing practices, improper fee assessments, and harassment. The investigation was ongoing, but they wanted me to know they were taking the matter seriously. A week later, Jim Rodriguez called me. "Did you see the neighborhood group?" "I do not follow it," I admitted. "Too much drama." "You should look," Jim said. "Sharon just resigned." I pulled up the Facebook group on my laptop. Sure enough, there was a post from Sharon Whitmore dated 2 hours earlier. "It is with great sadness that I announce my resignation as president of the Lakeshore Estates HOA board, effective immediately. After 12 years of service to this community, I have decided to step down to focus on personal matters. I am proud of what we have accomplished together and know the association will continue to thrive. Patricia Holloway will serve as interim president until a special election can be held." The comments were a mix of supportive messages from Sharon's core supporters and barely concealed relief from everyone else. Someone had posted a GIF of fireworks. Maria Rodriguez commented, "Thank you for your service. Looking forward to new leadership." "She did not resign voluntarily," David told me when I called to share the news. "The state investigation probably scared the board. They are trying to cut ties with her before things get worse." "Can they do that?" I asked. "Sure," David said. "If the investigation finds serious violations, they will want to claim it was all Sharon acting independently, not official board policy. Classic scapegoating." The special election was held in October. Patricia ran for president on a platform of healing community divisions and returning to HOA basics. She won easily, since Sharon's coalition had fallen apart. One of Patricia's first acts was to send me a personal letter apologizing for the conflicts of the past months. She proposed a meeting to start fresh and discuss reasonable community partnerships. I met her at a coffee shop in town, neutral territory. She looked tired and considerably less polished than she had at the courthouse. "Look," she said after we had gotten our drinks, "I am not going to pretend the board's actions were acceptable. They were not. Sharon went way too far and the rest of us should have stopped her sooner." "Why did not you?" I asked. Patricia sighed. "Honestly, because Sharon was effective at getting things done. She just did not know when to stop. She saw you as a threat to her authority and she became obsessed with winning." "I never wanted to be at war with the HOA," I said. "I just wanted to enjoy my property." "I know," Patricia said. "And you should be able to. I wanted to tell you that the board has officially acknowledged that your property is not subject to HOA covenants. We have updated our records, and you will not receive any more violation notices or fee demands." "I appreciate that," I said. "I also wanted to ask if you would consider letting us use your beach for the annual neighborhood 4th of July party next summer," Patricia said quickly. "Before you say no, hear me out. It would be one day, we would get everything in writing, we would pay you a reasonable rental fee, and we would have everything cleaned up and back to normal by the end of the day. The previous location we used is now developed, and we do not have a good alternative. Who would be organizing it? I asked. A volunteer committee, not the HOA board, Patricia said. Completely separate, just neighbors getting together. I thought about it. I thought about Jim and Maria and the other neighbors who had been kind to me. I thought about what kind of community I actually wanted to live in. Send me a proposal, I said. Specifics about timing, number of people, insurance, cleanup, I will consider it. Patricia looked surprised but pleased. Really, I said, but it is not a blank check. I want everything documented and agreed to in writing. Of course, Patricia said. Thank you for even considering it. In November, the Department of Financial Institutions released their findings. The Lakeshore Estates HOA was fined $15,000 for improper fee assessments and fraudulent billing practices. They were required to refund over $40,000 to various homeowners who had been improperly charged over the years. The board was also required to implement new oversight procedures and submit to annual audits for the next 5 years. Sharon was personally fined $5,000 and banned from serving on any HOA board in Wisconsin for 10 years. The report specifically cited my case as an example of egregious harassment and abuse of HOA authority. It recommended that Wisconsin strengthen its laws governing HOA conduct. I received copies of the report along with a formal letter of apology from the current board. In December, as snow began to fall over Lake Geneva, I was sitting in my living room working on a client presentation when my doorbell rang. I opened it to find Sharon standing on my porch. She looked different, smaller somehow, without the aggressive confidence she had always projected. Her blonde hair was loose around her shoulders and she was not wearing makeup. "Can I come in?" she asked quietly. Every instinct told me to say no, but curiosity won out. I stepped aside and let her enter. She stood awkwardly in my entryway, looking around at the house. "I wanted to apologize," she said finally. "In person, what I did was wrong, all of it. The trespassing, the harassment, the lawsuit, it was wrong and I am sorry." I did not know what to say. This was not the Sharon I had dealt with for months. "I lost myself somewhere along the way," she continued. "The HOA became my whole identity. When you challenged my authority over the beach, I could not handle it. I made it personal when it should have been about what was right." "Why are you telling me this?" I asked. "Because I have been in therapy since September, trying to understand why I acted the way I did," Sharon said. "And part of that process is making genuine amends to the people I hurt. You do not have to forgive me. I just wanted you to know that I understand what I did was wrong and I am working on being better." She pulled an envelope from her purse and handed it to me. "This is a check for $5,000. It is the amount of the fine I received from the state. I want you to have it. Consider it compensation for everything I put you through." I opened the envelope. Sure enough, there was a personal check made out to me for $5,000. "Sharon, I do not need your money," I said. "I know," she replied, "but I need to give it to you, please. Let me do this one thing to make it right." I looked at her tired face and saw genuine remorse there. Whatever else Sharon had been, she was a person who had made serious mistakes and was at least trying to own them. "Okay," I said. "I will accept this." She nodded, looking relieved. "Thank you. And I really am sorry." After she left, I stood holding the check for a long time. Then I sat down and wrote my own check to a local legal aid organization that helped low-income homeowners fight HOA disputes. $10,000. The $5,000 from Sharon, plus $5,000 of my own. If my fight with the HOA could help other people protect their homes, then maybe all the stress and conflict had been worth something. Winter settled over Lake Geneva. The lake froze solid by January, and ice fishing shanties dotted the surface. I worked from home, cozy and warm, occasionally breaking to watch the snow fall over my private beach. In February, Patricia sent me the formal proposal for the 4th of July party. It was thorough and professional. Maximum 60 people. Hours from noon to 9 p.m. The HOA would provide $2 million in liability insurance with me listed as additionally insured, professional cleanup crew hired, and a rental fee of $1,000 for the day. I had David review it. He suggested a few minor changes, which Patricia immediately agreed to. We signed the agreement in March. July 4th arrived warm and sunny. The neighborhood party was exactly what Patricia had promised. Well-organized, friendly, and respectful of my property. Kids played in the sand while adults grilled burgers and hot dogs. Someone brought a canoe and gave rides. As evening fell, families gathered on blankets to watch fireworks across the lake. Jim and Maria brought me a plate of food and sat with me on my deck. "This is nice," Maria said, watching the party below. "This is what the neighborhood should be." "Agreed," I said, as darkness fell and the first fireworks burst over the water. I felt something I had not felt in a long time: peace. This was why I had bought this place. Not to be at war with my neighbors, but to be part of a community while still maintaining my independence. The HOA had learned that property rights mattered. I had learned that being right did not mean being isolated. And Sharon had learned, hopefully, that power without accountability destroys everything it touches. The fireworks reflected on the dark water, red and gold and silver. Around me, my neighbors cheered and children laughed. My private beach, my hard-won refuge, was serving exactly the purpose I had always wanted, bringing joy without compromising my rights. The next morning, I woke early and walked down to the beach. The cleanup crew had been thorough. You could barely tell there had been a party. The sand was smooth, the dock was clean, and the lake was quiet in the dawn light. I sat on the end of my dock and let my feet dangle in the cool water. Somewhere across the lake, a loon called. A fish jumped, sending ripples across the glassy surface. This was worth fighting for. This peace, this beauty, this home. And now, finally, it was truly mine. The end.